We're live. All right, good morning. It is January 22nd. It's Senate Judiciary. We are taking up S-183, and we have Kim McManus from the State Attorney's and Sheriff's Office to provide their thoughts on those.
Thank you, Chair. Again, for the record, Kim McManus, Department of State Attorneys and Sheriffs. So our department does not have a position on this bill, and that is because we have differing opinions within the department on whether the statute as currently written is unconstitutional. Some agree with the Superior Court entry order in the Martin case that was essentially replicated in the Eaton case. Some do not. And there is ongoing litigation right now. We have, well, let me back up. We have approximately 80 to 85 pending home improvement fraud cases. I know at the moment we have a motion to dismiss pending in Orange County on 4 cases, and the state's attorney in that county has refuted the arguments presented in Martin, and it's a very interesting argument. We don't have to go into the weeds here. You can take a look at it if you like, or we can discuss it if the committee would like. But essentially, our position, again, we do not have a position on how you move forward. If because of the 2 Superior Court entry orders, you would like to clarify that your intent back in 2015 was to have this intent to defraud element, which again, many of our state's attorneys and deputy state's attorneys believe that that bill is in the existing statute. But if you wish to clarify it, no issue there. So the language that has been presented does clarify that and puts in an intent to defraud explicitly. We would just caution that as this body is discussing this and making changes, that it's not necessarily making the changes because it agrees that the current statute is unconstitutional. That is a question right now. And again, those entry orders are only binding on those cases. They're very well likely will be potentially out of Orange County, a case that eventually works its way up to the Supreme Court, and we will have a decision there. I'm happy to get into the weeds on home improvement fraud if you wish, but essentially we don't have any issue with reverting back to the 2015 language with that removal of the promissory insurance. We would just highlight again, one of the issues, and this has always been an issue, is that by adding the knowingly in the first part of the clause, it attaches that intent to defraud to when the contract is being entered into. And many times in these cases, the contractor may enter into the contract with no intent to defraud, but only as time has passed, right? Then converts the person's money into their possession by not doing the work or returning the money. So that's always been a tricky part of home improvement fraud. So if we wanted to spend more time thinking about how to structure the language, so it could be knowingly at the time of contract or any time during the contract, right? You then, your intent is to defraud, and then the language that suggested that you promised a performance that the person does not intend to perform. It's just something to consider. That would definitely give prosecutors more of an ability to meet that standard. Meeting it at the time when the contract is entered into can prove difficult.
I had some questions yesterday, and I had questions yesterday, and I don't know if you saw the testimony yesterday. I think it was. I actually don't remember who it was.
Yeah, I was watching the walkthrough. I think so.
Yeah, so I had some questions just about how these cases kind of play out, and my understanding is the Attorney General sort of oversees contractor fraud. I also have some questions because I view this as a consumer protection thing. So I'm just trying to understand the sort of interplay.
Yes, so there can be two routes, and you're highlighting an issue that our department has struggled with for a bit with these cases, especially in this B1 case. It's contract law, and usually when a contract is not fulfilled, that is a civil suit and would be a civil action brought by the complainant or a government entity. And there are civil, I think you heard from your witness that came in before the walkthrough that she tried to sue the contractor civilly. So there are actions that can be taken there. When you add the intent to defraud, that you've entered into a contract and you're doing so, you're a lie, deception, that's when the in Vermont and other places attach that as a criminal case. You can still have a civil case in the same facts and circumstances. So there are two paths that can be addressed. A struggle that many of our attorneys have is that you quickly become, even though this is in criminal court, you're arguing contract law, which we all had to take a year of contract law in law school, but generally we did not go into contract law. So it often feels like an area that's outside of our day-to-day. And there have been some in our department that these cases would be better suited for the Attorney General's office, who have the criminal division and the civil division and the consumer fraud piece, and that would make more sense for the cases to go in, be assessed, and then filtered into the proper division depending on the facts and circumstances of the case.
That certainly makes sense to me, and I wonder if it would be helpful to clarify that should be the process.
I don't think you'd hear any argument from us if home improvement fraud cases became, the absolute purview of the Attorney General's office, right?
But it just makes sense. Like, that's what I'm trying to understand. Because obviously, I'm not an attorney. I don't practice in any of the courts. But as I was trying to understand it, it seemed confusing. Sort of like, where does it go? How does it go? And when I think about it from sort of exactly the point you make, it just sort of makes sense. But that's where it would live. So that's great. I'm glad we agree.
Very happy to ever.
I love it. It makes things so easy.
Yeah, I think I'm interested in the discussion around the mens rea at the time of the formation of the contract versus whether it gets developed later on. And I'm trying to think of different analogies. And these aren't perfect analogies, but I'm thinking of somebody who, takes out a car loan, takes out a student loan with initially the intent to pay through the whole thing. Then they default on the loan, like a student loan, for example. They still have their degree, but they're broke. They're not paying the loan anymore. That type of circumstance, obviously that person is going to be prosecuted for a crime. However, on the other hand, if they're taking out loans to use them fraudulently, at the time that they're taking out the loan, that it's a crime from the beginning. So I don't know if that's best analogy, but that's kind of what I'm thinking about regarding the idea of potentially making it, adding the ability to have the mens rea develop later on after the contractor, takes the money, has the intent, maybe they even start the job, but for whatever reasons, they stop, whether it's because they go bankrupt, warehouse catches fire, or they, I don't know, for whatever reason might happen. So yeah, any thoughts on that?
Yeah, and again, what gets interesting there, right, is say the warehouse catches on fire, right? You didn't, at that moment, they're not intending, you're still not doing it, like this horrible thing happened to that contractor. There's no intent to harm those other individuals. So I would say in that example, like that wouldn't fit into that. But I think the scenario of, initially we tend to do the work. 3 months go by. Hey, where are you? The person is now sort of in that Ponzi scheme realm of like, oh no, like I needed my next job to pay for this job. Like I meant what I wanted to do then, but now I'm a mess and I'm behind and I'm intentionally avoiding those folks. I think that it's interesting. And again, this is where it falls quickly into contract law of whether it gets a little mind boggling. And I was thinking, one analogy, and it's not a perfect analogy, is I was thinking about embezzlement, right? When that person initially is taking the money, like there's always that at least when you hear these stories after the fact, it's like, oh, I'm not taking it, like I'm gonna put it back, right? And then the problem gets bigger and bigger, and then they can't put it back. You never say in those embezzlement cases like, oh, you can't put it back now, you're not guilty of that, because you knowingly took the money. Right, so again, it's not a perfect analogy, but I think if there was a way to practice that the fraud, the mens rea has shifted, it's either at the beginning or it occurs during the course of the contract. And again, it would still be the state's burden to show that shift occurred, that they are now intentionally defrauding that person. So burden would be on us, but at least it takes away that burden of having to show it all the intent was at the start of the contract. Something to consider.
Question that is sort of loosely related to this. And again, it comes from my not being an attorney, and but my understanding of intent is thoughts. And I'm curious how one proves what someone was thinking when they signed a contract or when they changed their mind.
Yes, so mens rea intent is almost always circumstantial evidence. The rare lucky case, you find someone's diary who's like, I plan to defraud Senator Norris today, right? Like that would be direct, wonderful evidence. We never get that, or almost never get that. Or the person admits it, then we know they're wrong. So we have to look at actions they've taken or not taken, to try and see what someone was thinking at the time, to see what mens rea would fit. So it's almost always circumstantial.
Gotcha. So I would imagine Senator Norris gave an example the other day about someone who had multiple people that they'd signed contracts with and never done any work, that would go into that bank of evidence to say, this is a pattern of behavior.
Exactly, right? He did it once, like maybe you attended it, but then he couldn't follow through for some reason. And you took on another client, right? Knowing you had no resources, knowing you owed someone else's work, right? That would build towards like what were you thinking at the time, what were you planning? When you purposely took on the loan, when you knowingly, and we would get that to make that understand.
Yeah, I don't know where to start on this one. First of all, I wasn't aware that I had heard rumors that there may be some constitutional issues involved in this. So in your testimony, you said you're holding on to like 80 or 85 home improvement fraud. Is that on the criminal side, or is that you're not holding on to civil?
No, we don't follow
you
the
don't do
civil cases, so these are all criminal.
So those 80 to 85 also listed under the backlog within our court systems?
And they're current cases right now.
Current cases that you're not going to do anything with presently, right?
Well, the cases that have been filed, in the county, they're still going forward with them. They're still litigating them in certain counties.
So are you indirectly suggesting that maybe we should just wait until we get that decision from this Orange County court Orange County,
I think it would be interesting. It is scheduled for March. The date it's scheduled for hearing near the beginning of March. The prosecutor in that case has actually submitted a motion asking to move the hearing up, knowing that there's pending legislation and they would like to get a decision out of there. I don't know if that's going to happen. I don't necessarily think you need to wait, because then you're if the argument goes forward and Orange County decides, oh, we agree with you, like this statute's constitutional, the case can go forward, you're gonna have two different counties, two different entry orders. Again, neither of them are binding on anything except for that specific case. So I don't know if you necessarily need to wait. I think it would be interesting and potentially informative. You could still clarify the intent to defraud, which was one of the issue. So from clarifying that would help greatly as far as this constitutional issue. So there's no harm in doing that.
see, my intent in re-looking at this bill was to offer some form of protection to alleged victims. And evidently, other than a silver road now, they don't have anywhere else to go. And that can be costly, as we know, going through civil court. And this particular case, we know someone was down approximately $50,000, and they pretty much said, you know what? We're done throwing money into this. You know, I don't feel that that's right. And I'm sure you all don't feel that that's right either. So, you know, quite possibly, I guess we could entertain the mens rea later on, Lauren, versus one alleged victim right up front. If that works better for us. But it feels slow, like we're just sitting out on the sailboat waiting for the wind to come up here to get a decision someplace, so to speak.
I mean, yeah, I mean, that's why our department doesn't have a position, because it is, there's differing opinions on the folks are interpreting the law differently. Again, the changes suggested to address the issues raised in the Martin and Eaton case. So if, say, it trickled out and the counties various judges adopted this thinking, these changes would help moving forward and take away that issue so that the cases could move forward.
And in reference to, like, you can't force someone to work for the servitude issue. Right, you can, but they took $15,000. We don't need to just give us the $15,000, but we need to find a way around this to help people within the state here. The courts should be different on their opinions throughout the state.
And again, the changes here would address that by taking out that essentially the issue in the Martin case was that an element of the crime is not doing the work and attaching that to that being that servitude. And so by removing that, again, you remove that argument against the statute. So it would help the issue that's been raised by two courts so far.
Thank you. Any additional testimony or any other thoughts you wanted to share?
Yeah.
Oh, great. Thank you. Hold on. Camera, I just pointed.
Well, can I
I think we're still on live.
I didn't realize that I did it. Sorry.
It's just, see? There we go.
And he's an IT expert too.
Thank you so much. That would be said by IT expert. Good morning, Todd Dalos, from the Attorney General's office. Thanks for having me here today. As Senator Norris flagged, this is a small but really important issue for a lot of homeowners. These cases cost tens of thousands of dollars and often leave homes in a fair degree of disarray. And folks just waiting for something to happen. I think the legislature's push in initially passing this bill and this law, and then subsequently amending it was to provide something beyond the civil remedies, the kind of contract dispute remedies that exist in other areas of the law. To really address the concerns that victims were facing. Broadly, the Attorney General's office agrees with the testimony that Kim provided in terms of the options for addressing this issue. We're not engaged in the appeal, but we're supportive of where the state's attorneys are looking at this and remain sort of waiting to see what happens with the court. I think to the point Kim raised, which is a really important one, what do we do if an individual enters the contract and there's no evidence of fraudulent intent at the time, but over time, they begin the work, there may be an amendment, a change order, something like that. And maybe at that moment, it's easier or more possible to prove knowing intent. One small amendment we would recommend in that is just a very slight change to add the concept of a change order. Any kind of written agreement, email that suggests additional work, additional payment, so that as opposed to having to demonstrate the first day there was fraudulent intent or even a formal amendment to the contract, something that, and again, a change order may capture it, but we can certainly talk more with Ledge Counsel about language to capture the evolution of these cases. Because I think the example or the analogy Kim gave about contractors stepping into a case, into a job without fraudulent intent and then running out of money for that job, needing a subsequent job to pay for the previous job. And then at that point, kind of falling into this getting behind. It's not quite the same as student loan debt. But I think it becomes a little bit lower of a burden for the prosecutors to demonstrate that fraudulent intent if there are checkpoints along the way. If there's a way, and I don't have language on this, to kind of make it a smooth spectrum for the prosecutor to demonstrate at any point along that timeline that there's fraudulent intent, that would certainly work as well. But one simple recommendation for 20.9D would be to add change order there in a couple different spots. Beyond that, Senator Mahoney, your question about sort of where is the world of home improvement fund? So I do think it's important, and I'm going to make a little budget pitch. We do have a big consumer unit at the AGO, and we do handle a lot of consumer complaints in the civil realm around this. It's sort of an earlier stage, usually, than any kind of criminal prosecution might be. And we have an individual at the Consumer Assistance Program who is a home improvement specialist and works with both homeowners and contractors kind of as a mediator to help solve or work through a lot of these disputes at an earlier stage when possible. And he happens to be both a former contractor and a paralegal, so he brings an incredible degree of skill to it. The budget pitch is, he's not in the budget. He has been a limited term service position with a year-over-year. It's a very low value, I think around $85,000 cost for his position. And I believe at last check, which was about 6 months ago, he helped recover either for contractors or for homeowners something in the neighborhood of $800,000. And so that is, we have seen since the Washington County case came down last March, more home improvement work shifting to that civil consumer fraud arena. And in response to that, this position seems even more important. So I'll make that pitch for FY27 through the appropriate channel, but I wanted this committee because it's not really criminal, which is what the judiciary generally deals with. But it is definitely a layer on this. I'm happy to speak about sort of where the criminal prosecution lies for home improvement fraud. I would suggest a couple of things there. The only area where the AG has sort of specific and exclusive jurisdiction, there's, I think this committee knows, it's overlapping jurisdiction, concurrent jurisdiction across the state and the state's attorney's office. Homicide is the only area that the legislature has said AG has exclusive jurisdiction on homicides. That's not something they exercise. We usually work in collaboration with state's attorneys around how to respond to homicides. Home improvement fraud generally is a misdemeanor case, and just I'm happy to respond to that. That's a proposal the committee seems to want to move forward with, is handing all of that work to the AGO. just on a pure logistics note, so we have a criminal division that's roughly the size of the Washington County State's Attorney's Office, about 6 attorneys. It would require those folks to travel just on a simple level all over the state to respond to these misdemeanor cases. And would really pull those resources from the ICAC work we did, which is the internet child, internet crimes against children one, and the homicide work we do. But again, I'm happy to have the criminal division come in and talk about what that might be.
For the homicide cases, how many, well, I know you may not have the numbers in front of you, but what are the numbers of the cases that are in the criminal division in your office right now? Like how many homicides?
Those to you. Yeah.
Do you know how many homicides by any chance?
I can get that breakdown. I think homicides, there are a number that are specifically where the prosecuting office, there are a number where we're assisting, and there are a number where we're providing support in other ways, whether it's deposition support, sort of the background work. I will get you the breakdown.
And one other question, going back a couple of minutes here, regarding the change order. I wasn't sure I fully understood. So is it the suggestion that evidence from the contractor as to whether or not they made changes to the contract, like, making an addendum that says this work is actually going to take the next 6 months and we're not going to finish on time, that those orders can be used as evidence?
Yeah, essentially that any written evidence that demonstrated a change to the contract. Right. So, hey, we prefer it if you add some trim to the kitchen or whatever it is, and the contractor says, great, that'll be an additional $3,200. If at that moment there's a demonstration that there was no intent to ever carry through on that change order, that would be an additional checkpoint, as opposed to just saying the original kitchen remodel. Once they sign that contract, if they're struggling, examine that. It would just give more opportunity to demonstrate the role.
So one of the examples that previous testimony what his gave us was that they said they needed a certain amount of money to order this special window. Weeks later, they go check with and this individual never showed up, never ordered the window, but held the money. So that also falls to that same category that you're talking about. So let me give you a hypothetical situation, see if you feel comfortable with an answer. So say I bring my car into a garage, or she says, well, it's going to cost $1,000, I need $500 up front from partners. Car sits there for 3 months. Nothing's done. They get my $500. Criminal civil.
I mean, it would be a very challenging criminal case.
I'm just wondering if we should expand the scope of what we're talking about here.
I think the challenge will be, and I think Kim spoke to this eloquently, to demonstrate the mens rea, to demonstrate the criminal intent, with generally speaking, out the benefit of the person's thoughts, as the Fifth Amendment is going to protect them. It's always going to be really challenging with that circumstantial evidence. And there are civil avenues, but I absolutely understand it. I think they do not meet the needs of many of the victims. I mean, I think if we read the case out of Franklin County that followed up on the case, I think it's Eden. That individual had gone to small claims court, right? Had looked for civil remedies and they were lacking for them, and that's when it became criminal. So I don't have an opinion on other areas.
Absolutely. I mean, I think the sad reality is unfortunately the criminal justice system often doesn't meet the needs of the victims that it purports to. My question though is in the instance of the case where the person said, yep, sure, and then, months later had never actually ordered that special thing, would that play into that ability to prove, well, you said you'd do it, you never even ordered for it?
I mean, I think a prosecutor would use all available as Kim said, circumstantial evidence, not the direct evidence I thought acts, but evidence that tends to prove that the person has never got carried through the contract, the amendment, the change order, the amendment. I mean, I understand it's a very challenging area. I think, that's part of the reason that the Martin decision has met success in other areas of the state, is because there's a viewpoint that the inability to pay requires servitude. Without that form, will force criminal servitude. Rules, I mean, again, I think as Tim said, there's a hearing coming up and a decision in the Supreme Court will be enlightening, but it doesn't necessarily have stances.
Kim, I saw you, briefing.
Just wanted to clarify for the record, there's a hearing scheduled in Orange County,
Oh,
the Superior
it's not
Court level.
Well,
It's not, but it's potentially something that could be accused. It's report, but we don't have the initial decision yet. Orange County.
Thank you. Anything else, committee? Great. Thank you.
thank you.
Did you clear things up real well for me?
All right, we can go off